judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to the Court of Appeals. My name is John Tyson. Your panel this afternoon consists of, to my right, Judge Jeffrey Carpenter, to my left, Judge Tom Murray. We're very pleased to be back at our alma mater this afternoon at Campbell, and we appreciate counsel coming to the law school today to argue the case here. We are here with our marshal, Tom Salute. We thank you for being here today, and we will be available after arguments are over if there are any questions from the attendees that are here. And there's also a reception that is planned down in the lobby following the conclusion of court. So we have one case on the docket this afternoon. The style of the case is now Stein versus Berger. I see the parties are here. Are there any preliminary matters to come before the court before we get started?
Your Honor, it may be worth informing the court, because this is a cross appeal,
Yes,
that we've agreed to 25 minutes each initially, with each of us having 5 minutes of rebuttal.
Okay, so based on the cross appeal, you each will, do you have a sequence on which you want to do that?
25, 25, 5, 5.
Understood, okay. So we'll hear from the appellate. Which appellate are we going to hear from today?
I'll be the first one, Your Honor.
Okay. Good afternoon.
Good afternoon. May it please the court, my name is Jim Phillips with the law firm of Brooks, Pierce, McLendon, Humphrey, and Leonard. I'm here with my partners, Amanda Hawkins and Eric David. We come on behalf of Governor Josh Stein, challenging the constitutionality of two pieces of legislation that restructure 7 executive boards and commissions. Each of those 7 boards has the authority to make final executive decisions. They issue and revoke permits, they levy fines, they set standards, they make rules, they make policy when that is delegated from the General Assembly. Each of the boards is charged with executing and enforcing the laws enacted by the General Assembly. And all but one is located, housed in a principal department overseen by the governor. The General Assembly's restructuring of these boards and commissions is unconstitutional because they violate Article 1, Section 6 of the North Carolina Constitution, which commands that the legislative, executive, and judicial power of the state shall be forever separate and distinct from each other. That separation of powers violation occurs because these restructurings interfere with the governor's duty, his authority, in Section 3, Article 3, Section 5.4. that the laws be faithfully executed. This is not the first time in recent memory that the General Assembly has tried to deprive the governor of the power to execute the law. And it is not the first time that a governor has been forced to call upon our courts to enforce the commands of the Constitution and protect against the accumulation of too much power in one branch of our state government. As that history demonstrates, this dispute is not about partisan politics. It is about respecting and protecting the genius of our republic. Our Supreme Court has called the separation of powers the cornerstone of our democracy, necessary for the preservation of liberty. Governor Stein asks you today to protect our democracy and our liberty by declaring these laws unconstitutional. Our Supreme Court has done just that in 3 cases that control the decision here. Those cases establish the analytical framework for a assessing a separation of powers issue related to executive boards and commissions, and provides the test for this court to apply. In Wallace v. Bone, the first of those cases, a 1982 decision of our Supreme Court, the General Assembly passed a law which authorized the appointment of 4 sitting legislators to the Environmental Management Commission, one of the boards at issue here. The court found it crystal clear that the EMC was administrative or executive in nature, and held that, and I quote, "The legislature cannot constitutionally create a special instrumentality of government to implement specific legislation and then retain some control over the process of implementation by appointing legislators to the governing body of the instrumentality." Of course, the restructured Economic Incentives Commission, which is before the court today, violates this holding by appointing 2 sitting legislators to that body. The second decision came in McCrory versus Berger, when Governor McCrory challenged on separation of powers grounds the structures of 3 commissions which were housed in the Department of Environmental Quality. Because the governor and not the General Assembly appointed a majority of the members of each of those commissions. Writing for the court, Chief Justice Martin found that the structure of those commissions violated separation of powers because they interfered with the governor's constitutional duty to faithfully execute the law. The court held that because each of the commissions had the final say on executive decisions, the governor must have enough control over them to ensure his ability to do that constitutional duty, to faithfully execute the law. The court assessed the governor's degree of control by looking at the governor's ability to appoint the members, to supervise their day-to-day activity, and to remove them. Because the governor appointed only a minority of the commission members and could remove them only for cause, what the court called significantly restrained removal power, the court found a separation of powers violation. The court's holding was clear and speaks directly to the issue before us today. The court said, "We hold that the challenge appointment provisions violate the separation of powers laws. When the General Assembly appoints executive officers that the governor has little power to remove, it can appoint them essentially without the governor's influence. That leaves the governor with little control over the views and priorities of the officers that the General Assembly appoints. When those officers form a majority on a commission that has the final say on how to execute the law, the General Assembly, not the governor, can exert most of the control over the executive policy that is implemented in any area of the law the commission regulates. As a result, the governor cannot take care the laws are faithfully executed in that area." 2 years later, our Supreme Court decided Cooper versus Berger, which involved the General Assembly's restructuring of the State Board of Elections. The General Assembly's restructuring called for an 8-member board with 4 members appointed upon the recommendation of the Republican State Party Chair and 4 by the Democratic State Party Chair. The governor could remove members, but only for cause. The chair of the board was elected by the members. Governor Cooper challenged the law on separation of powers grounds, just as Governor McCrory had before, contending that it interfered with his duty of faithful execution. Now, a couple of facts were different in Cooper than in McCrory. First, the board was split evenly, but the governor still didn't have a majority. And secondly, a third party, not the General Assembly, in effect, made the appointments. The court applied the test set out in McCrory, examining the governor's ability to appoint, to remove, and to supervise the board members, and examined whether the degree of control that gave the governor was sufficient for him to perform his duty of faithful execution. In the context of the boards and commissions that make final executive decisions, the court determined that the Constitution required the governor must have enough control over the board to affirmatively implement the policy decisions that executive branch agencies subject to his control are allowed through delegation by the General Assembly.
So what's enough control?
Enough control is the ability to drive the final executive policy decisions that those boards make. That's what McCrory said, and that's what Cooper says. That enough control is the ability to have a majority that you can remove. It's a functional test, but both of these cases say you must have enough control so that the governor has the final say over the executive policy that they make.
Now, if the governor retains majority appointment, is that sufficient?
Your Honor, in the context of boards and commissions, it depends. So, for instance, we have before us the Residential Code Council. The governor appoints a majority of those members, but it takes a supermajority for the board to take any action. So in that instance, no. In most instances, I think if there are, 11 members and the governor appoints 6, then McCrory and Cooper would hold, I think, that is sufficient. But there are circumstances, I think, and this supermajority example is one of them, where I think the answer is not.
In the cases or the boards that are before us today, what was the split, or how did the change impact the former composition of the board?
So, in the context of, so Your Honor, what the General Assembly has done here is they've sort of put out a smorgasbord. It's like testing you all to see what you'll say okay to. And so there are a variety of different ones. I intend to go through and address each of these, and in the context of that, if you would, I will tell you what happened. I will say to begin with that with regard to all of these boards before, the governor had a majority of the appointments.
Not all of them.
I believe so.
So before the change, the statute, the governor appointed all the members of each.
No, he appointed a majority.
Okay.
I'm sorry. Thank you, Your Honor. So, addressing your question, applying McCrory and Cooper to the case here, to the facts here, and to be clear, we believe that those two decisions control. They direct that whereas here, the governor is deprived of the ability to appoint a majority of the board members that make final executive decisions, particularly a board housed in an agency overseen by the governor, and where his removal authority is either taken away entirely or sharply constrained as it is here, that interferes with his ability to faithfully execute the law. Now, turning to the specific boards at issue. First, the Economic Investment, the Board of Transportation, and the Residential Code Council. Those are clearly controlled by Wallace and McCrory. The EIC and Board of Transportation provide now for the appointment of a majority of the members by the General Assembly. 4 of 7 with the EIC, 14 of 20 with the DOT Board, with 2 members of the EIC being sitting members of the General Assembly. As we just discussed, the Residential Code Council, the governor actually appoints 7 of 13 board members, but 9 members are required to act. So as in McCrory, And also, as in McCrory, the governor may remove members of the EIC and the Residential Code Council for cause while having no authority to remove the General Assembly's appointments to the Board of Transportation. The legislative defendants' only argument with regard to these three boards is that they are not executive in nature, but an examination of the general statutes which empower these boards and the affidavits which we've submitted from the board chairs and board members clearly shows otherwise. It's noteworthy that the three-judge panel found the EIC and the Board of Transportation, all of these boards, in fact, primarily executive or administrative in nature. The three-judge panel, however, found the Residential Code Council acceptable because the governor appointed a majority. But when a supermajority is required to act, that falls squarely within the holding of McCrory.
Well, the governor has to appoint the chair of the Residential Code Council. How does that play into this analysis?
Your Honor, in order for the board to even meet, a quorum is 9 people. So who the chair is doesn't really give him any ability to supervise their activity, because if the members of the legislative appointees don't show up, the board can take no action. Clearly, the governor is circumscribed in his ability to control and oversee that board.
But if they do show up, that gives the governor the numbers that you described would give him control.
No, Your Honor, it would not, because 9 people have to vote to approve something. The governor has only 7 appointees, so they still control the outcome. The simple fact that it's a majority, they is the General Assembly. So
let's talk a minute about control. You've in cases used control, the term control. Control in Wallace, correct me if I'm wrong, control in Wallace was there was legislative members on that board. I.e. the legislature had control by having their members on the board.
I think the concept of...
I'm sorry. Are control of the appointments, not actual control of the members by having members of the legislature on the board. Control, the term control is used differently in the cases.
So I don't think control really comes into play much in Wallace. It just says that the General Assembly can't reserve itself the ability to implement the law that it enacts by putting legislators on the board. That's a pretty straightforward black and white test. The concept of control does come into play in McCrory and again in Cooper, because Chief Justice Martin is clear that the governor must have enough control of the board to oversee and implement the executive policy that those boards and commissions are allowed. And Cooper goes a little further and says that by control, we meant that the governor has to have the ability to affirmatively implement the policy decisions that executive branch agencies subject to his control are allowed through delegation by the General Assembly. So it is the governor as the officer who is duty-bound to faithfully execute the law, who has to have enough control to oversee and to control the final executive decisions that those boards are authorized to make.
Executive branch agency, is that in your mind the same as a board or commission that is legislatively created?
Yes, I think these are executive branch agencies. All of these boards are that. They have final decision-making authority and executive decision-making authority. That's assigned to that board or commission, to each one of these. And I think they are agencies as is used in both McCrory and Cooper. Turning now to the three environmental boards, or to the Environment Management Commission, the Coastal Resources Commission, and the Wildlife Commission.
So before you go there, Counselor, I would take it then that you are agreeing with the three-judge panel's decision as it related to the Board of Transportation and to the Economic Investment Committee. Is that correct?
That is correct, Your Honor.
And you would ask the court to affirm that decision?
That is correct, and those are the subject of the prosecutor.
Right.
Thank you very much.
So now you're turning to,
I'm turning to the EMC, the Coastal Resources Commission, and the Wildlife Resources Commission. Under the new structure, the Environmental Management Commission has 15 members. The governor appoints 7, the General Assembly 6, and the Commissioner of Agriculture 2. The governor can remove only his 7 appointees and only for cause. The Coastal Resources Commission has 13 members, 6 and 6 from the governor and the General Assembly, 1 from the Commissioner of Insurance. Removal is the same. The governor only can remove his appointees. The Wildlife Resources Commission is a 21-member board, 10 and 10 between the governor and the General Assembly, 1 to the Commissioner of Agriculture. The governor can remove his appointees for any reason, the others only for cause.
do those commissions appoint their own chairs, or are the chairs appointed?
The board elects the chair, I believe, Your Honor, in each of those instances. Applying McCrory and
A
Cooper.
majority of the board.
I'm sorry.
A majority of the
A
board.
majority, that's right. So that's right. Applying McCrory and Cooper to these structures and analyzing the degree of control the governor has based on his ability to appoint, remove, and supervise, it's clear that these structures are constitutionally impermissible.
Now, did either McCrory or Cooper 1 require that removal of another entity's appointee is the constitutional standard?
No, it didn't, Your Honor. It said you look at all 3 things: the governor's ability to appoint, his ability to remove, and his ability to supervise. If he doesn't have a majority of the appointments, and he doesn't have the ability to remove appointees of another body, General Assembly, the Commissioner of Agriculture, then that significantly constrains his ability to oversee and supervise the policy decisions and the final executive decisions that they make. So the less ability the governor has to remove plays into the analysis. And here he can't remove their appointments.
Let me ask you this, as far as the non-legislative, talking about separation of powers, as it relates to the non-legislative appointees, i.e. the Commissioner of Agriculture or the Commissioner of Insurance, those are considered executive agents, or at least executive members of the executive branch. Is that correct?
Yes, sir.
So how do we regard those appointments vis-a-vis the separation of powers issue?
Your Honor, I believe that what the 3-judge panel found is that the executive branch was appointing the majority, and that was good enough. We think
Which would include the commissioner's appointees.
Correct. We think that is wrong. Because if you look at these, first of all, again, all 3 of those boards where the Commissioner of Agriculture and Insurance have appointments, those are housed in an agency, in a principal department overseen by the governor. And I think it would be fine for the General Assembly to assign some appointments to the members of the Council of State, but not such that that deprives the governor of a majority, or puts him in the minority, which all of these do. He has a minority of the appointments to each of these boards and commissions.
So do we look at the executive branch, or do we look at the governor?
You look at the governor. Your Honor, first of all, the plain language of Article 3, Section 5.4 makes it clear that it is the governor, and the governor alone, who has the duty of faithful execution. Again, all of these are housed in a principal department controlled by the governor. While the Council of State it's appropriate for the General Assembly to assign them appointments, it is not fine such that they take away the governor's majority, his ability to control the final decisions of the board, and take away his ability to faithfully execute the law. According to these appointments to the Council of State, also flies in the face of the election that the people have voted in. They voted, these departments are under the governor's purview. They expect the governor to oversee the policy that those, and the decisions that those boards make. But now he doesn't have the authority to do that. It makes a mockery of the people's vote. How are they to demand accountability when it's not the governor, even though he runs the department, who controls the decisions that these make? Also, you have to remember it's the General Assembly here who is picking the pickers. They're choosing members of the Council of State who they want to have make these appointments. It's also worth noting that the record on appeal is very clear that from a factual basis, after these appointments were made at the EMC, after the Commissioner of Agriculture made his 2 appointments, and the board was now controlled by the Commissioner of Agriculture and the General Assembly, the board voted 8-7 to oust the chair that the governor had appointed, to dismiss a lawsuit that the governor had wanted filed, and they had stymied rulemaking on a variety of environmental issues. If the General Assembly wants to do those things, it can make a law telling the EMC not to do those things.
Can the General Assembly also make a law that says the EMC is abolished?
Yes, absolutely. Your Honor, I'll take my 5 minutes when my turn comes again.
All righty.
I
I had you down for another 37 seconds. If you need that, I will certainly give it to you, but
I'll wait. I'll reserve 5 minutes and 37 seconds.
you can. Hear from the cross appellee.
Good afternoon. May it please the court, Matthew Tilley with the law firm Womble Bond Dickinson. I'm joined here with my partner Emmett Whalen on behalf of legislative defendants President Pro Tem Senator Philip Berger and Speaker of the House Destin Hall.
Is the Council of State members represented in this lawsuit?
They are not, sir.
Either one?
Either one. Just to be clear, and I want to be clear from the briefing, because every brief the governor filed, or the previous governor filed, suggested something that I think is just simply not true. And so I want to be clear about what we are and are not here asking you at this court to do. As we have said, the governor has argued against a number of straw man arguments. One of those is that because we saw a bypass petition to the Supreme Court, arguing that McCory and Cooper are wrongly decided, that we have somehow given a recognition that our case is foreclosed here. That is not true. The fact that we believe McCory and Cooper assert the wrong test and should be overturned if this reaches the Supreme Court does not mean that every board and commission fails to meet the functional case-by-case analysis that those 2 cases require. The panel properly recognized this with respect to 5 of the boards and commissions that issued: the Environmental Management Commission, Coastal Resources Commission, Wildlife Commission, Commission for Public Health, and the Residential Code Council. We believe that it also should have distinguished the Board of Transportation and the Economic Investment Committee, because those either are functionally different than the other types of boards and commissions here. They're more akin to places where the court has indicated there is broader latitude in the case of the Board of Transportation, or in the case of the Economic Investment Committee, we believe that it implicates in an advisory function core legislative functions.
Let me ask you this,
Yes,
if I may. Where the governor is appointing the head of the agency, commerce, revenue, all the way down,
Yes, sir.
as opposed to where the council state member is elected.
Yes, sir.
If the commission is taking its authority under an elected council of state versus an appointed cabinet member, does that make a difference?
The court has indicated in both McCrory and then again in Cooper confirmation that it had never opined on what would happen if you had an agency that was not a principal executive agency, so under the supervision of one of the cabinet agencies over which the governor
Like you said,
receives.
independent agency.
Independent. But instead, it had been moved to a department under one of the council of state members. Obviously, those are separate constitutional officers. They have some role. They are elected statewide. They are defined as part of the executive branch. And the Constitution says in Article 3, Section 7.2, that the General Assembly shall assign their duties. So if they're to have some duties, obviously those duties are somewhat executive because of what else would they be, there has to be room for the General Assembly to assign those there. All executive functions can't land in the governor as a matter of structure of our Constitution. We believe,
So to add on to that then, you're not making a distinction between a commission or board that's implementing a cabinet appointee as opposed to an independent board or commission that's implementing executive branch policy.
we have, no sir, we're not drawing that distinction. There is one board and commission in this case that is not housed under a principal agency under the department under the governor, and that's the Residential Code Council. That's housed in the Department of Insurance under the Commissioner of Insurance. And so we do believe that there's probably more room as a matter of constitutional analysis for there to be more independence there. But again, we're talking about a multi-factor balancing test of a number of factors at this point. We also think that neither McCrory nor Cooper dictate the outcome in that situation because they expressly said that they didn't.
Well, the three-judge panel below disagreed with you as it related to the transportation and the EIC. Is that correct?
That's correct, sir.
They found that the governor could not achieve the executive function without having control over those two.
That's correct. That's correct.
And you cross-appealed on that.
We cross-appealed
I do
on
understand
that.
that.
We cross-appealed on that, yes, sir.
So is that a distinction without a difference then, or how do you reconcile how that panel came to that conclusion?
The panel said that there is broader latitude when the functions, first of all, McCrory and Cooper established a case-by-case analysis that is functional, not formulaic, that is supposed to be interpreted in the context of the statutory scheme at issue, the functions of the board, what is desirable there, and balancing the control of the number of appointments, day-to-day supervision, and removal. So we have a lot of factors going on. They then drop a footnote in those cases, and again in Cooper confirmation, that says there should be broader latitude when the functions are different, and they point to the Rules Review Commission, which has an oversight and advisory function. It has a check function against the executive. All of the 10 members of the Rules Review Commission are appointed by the legislature. So clearly the court saw some sliding scale based on functions. The Board of Transportation 10 years ago, sir, I would have submitted to you was a much more executive set of functions than it is today. In reaction to investigations by the auditor and an overrun of roughly $750 million beyond the Highway Trust Fund's budget, the auditor recommended that there be greater oversight. And the functions of the Board of Transportation shifted to that of a fiduciary and that to an overseer, more of oversight. And the statute now says that they serve as fiduciaries over the State Highway Trust Fund and are there to ensure its solvency, and limits the board's duties. It says it shall not make decisions on individual contracts. Further, while there are duties listed that would seem to be executive, the statute requires that they be delegated to the secretary, who's under the direct control. So the ability to approve highway construction projects is by law delegated to the secretary under the direct control, who serves at the pleasure of the governor. Awarding of highway construction contracts is the same. And then as a matter of policy and pursuant to statute, this is all GS 143B-350, the ability to make rules is delegated to the secretary, again, who serves at the pleasure of the governor. The remaining powers are very limited. Advise the secretary on matters of performance, ascertain the transportation needs of the state, assist the secretary, review statewide maintenance plans, review the spend plan, which is the overall plan for spending, to make sure, again, that it is solvent. The board doesn't exercise final authority over that. It also doesn't exercise final authority over even the approval of the spend plan. In GS 143C-6.11.1, the spend plan has to not only be approved by the Board of Transportation, but the state budget director and the transportation oversight manager at OSBM. Our submission, sir, is that the Board of Transportation no longer executes final executive authority, at least in its predominant functions, but is much more akin to the Rules Review Commission in its oversight function.
I would presume that you made that argument before the three-judge panel below,
We did, sir.
and they did not agree with you.
They did not. Sir, I believe if you look at the through line of their decisions, they saw any place where the executive had a majority of the appointments, they found it constitutional. Any place where the executive did not have, in combination, council, state member, and the governor, did not have a majority, they found it unconstitutional.
I'm sorry. No, I was just asking, and it may be in the materials, but the constitution of the Board of Transportation, is it solely governor and legislative appointments?
It is solely governor and legislative appointments. It is 14 district appointments based on geographical regions across the state, 6 at large. Prior to Senate Bill 512, the 6 at large were appointed by the General Assembly, 3 by the House, 3 by the Senate. Then the districts were done by the 14 district seats were done by the governor. It flips under 512. The 14 districts are appointed by House and Senate, respectively. They're divided up 1 and 1 each. And the 6 are appointed by the governor.
So that is a case where the majority control of the board did change?
Yes, sir. But we would again point to those footnotes analyzing to the Rules Review Commission, which has an oversight function. All 10 of the members of the Rules Review Commission are appointed by the legislature. And the court cited that proof.
So I don't want to direct your argument, but could you also, while we're there, could you also explain the three-judge panel's decision as related to the Economic Investment Committee?
Yes, and I would submit that this is possibly the hardest case because there are sitting members of the legislature on this panel, at least by statute. Now, there's an alternative in statute, and you could sever it.
Does Wallace, is that per se?
If this is executive, Wallace would be per se. That statute is severable, at least insofar as it says it's the sitting legislators or their designees. And if it's the designee, and if you were to X out the legislators and leave only their designees, there'd be a different question. And you'd be back under the McCrory functional analysis, not in the Wallace per se fund.
Two current appointees, are they sitting legislators or are they designees?
I believe that at least one of them has made a designation as to the member. But Wallace v. Bone only prohibits legislators from serving on commissions that perform executive functions. And in that case, the court went further, and it said, first of all, that it viewed the crystal clear that the E&C, which issues permits, makes rules and does other things, makes final decisions, was clearly administrative. But we agree with Kansas and South Carolina that there should be cooperation between the legislative and executive branches. For many years, North Carolina has recognized and benefited from cooperative efforts between the branches of government. The best examples are various study commissions in which legislators and non-legislators have served. So if it's not executive function, if it has some other advisory function or some other coordination function, Wallace even leaves some room for legislators to serve outside of just the legislature. The Economic Investment Committee's work on the JGIG program, which is the primary grant that it deals with, is unique. in that it unlike almost any other contract anywhere in state government, when there's a grant issue, and I don't believe that it's issued by the EIC, I believe it's issued by the Secretary and the contract signed by the Attorney General, and I'll get to that in just a second. It requires future appropriations. There's a legislative provision that says the legislature intends to make those future appropriations, but it's a 30-year grant. That creates quite a budget obligation, and it says further something else that is not, that it really has no parallel in other contracts other than bonds, which is that it is a binding obligation on the state, regardless as to appropriations. So I would submit that this involves a pretty significant exercise of the appropriations power and commitment of the state to future appropriations. So that grant to work, you need to be, whoever it is that's moving, the company that's moving to North Carolina needs to know those appropriations are going to be made, and there's a reason to put the legislators there to make sure.
And when you said the Secretary, you mean the Secretary of Commerce? And
The Secretary of Commerce. I don't believe that that the EIC makes the final decision. It's very clear with respect to two of the grants, and this is all spelled out in our brief, but with respect to two of the grants called a JMAC and an SDIV, and I can do the acronyms, but those are not final. The EIC only makes a recommendation, the Secretary issues the grant. The statute is a little bit less clear with respect to the JDIG, except for this. It says that once the grant is approved by the EIC, it still must be subject to a grant agreement approved and signed and executed by the Secretary of Commerce and the Attorney General. So unless those two officers were to sign off, the EIC's vote to grant the JDIG wouldn't occur. The grant wouldn't issue. And so we would submit that they're involved in legislative functions and considerations. And in addition to that, the EIC is not making final executive decisions with respect to the JDIG.
Now, the trial court, in its order, as it related to the EIC, said, of these, the parties agree that the JDIG program represents the bulk of the committee's work.
We agree to that, sir.
So, but you're still appealing that decision. That's part of your cross appeal.
Yes, sir. Because we don't believe that the JDIG issues the moment the EIC votes to approve it. We instead believe that it's still subject at that point to the Secretary of Commerce and the Attorney General approving it as well.
Does any of that go before the Council of State or just before the Secretary of Commerce and the Attorney General? Do you know?
That is just the Secretary of Commerce and the Attorney General on that case.
So the Council of State does not vote?
The Council of State considerations and the plural versus unitary executive discussion that we've had doesn't have any effect on the EIC issues.
Of the 7 boards and commissions that we're dealing with in this appeal, which, if any of them, do you believe are executive? We're talking about McCrory and Berger, Cooper. Which of the 7 do you believe are executive, if any?
Sir, we believe, now, this is not to say that they don't exercise quasi-legislative or quasi-judicial functions, but I would submit that the ENCCRC, the Wildlife Research Council, the Commission for Public Health, the Residential Code Council, and to some degree possibly the DOT, although there's a question about that one, about where it fits, have executive functions. But they are some of them are quasi-legislative or quasi-judicial. In the DOT's case, they're oversight. In the case of the Residential Code Council, many of them are not final. So there are some distinctions there to be drawn. And according, Cooper would say that you have to weigh all of that. Because the question, what's the Rules Review Commission, I think comes up, and I don't know that there's any case squarely placing it in one branch or the other. But if it is an oversight and advisory function, the court said that there is broader latitude there. And so we believe that you have to look at the functions in addition to just simply which branch. It's not that formalistic. It doesn't say just because it's in the executive branch, it's final executive authority, and that the governor has to have the majority. The court said there could be broader latitude.
On the boards and commissions that involve the governor having a majority of the appointments, but requiring more than a simple majority vote to act, how does the governor carry out his duties and take care of them?
Your Honor, I think he's got significant power, and I do want to correct one statement where I believe that the Governor's Council put words in our mouth that I would not agree with, which is that we think that the only reason the Residential Code Council should be upheld is because it doesn't perform executive functions. We believe the Governor has enough control. The Governor appoints a majority of the members of that commission. He appoints the chair who can control the call of the commission, its agenda, and various other things. And so he's got more control than he would otherwise. It's also clear because of the structure that commission or council has 13 members, 7 appointed by the Governor, and 6 appointed by the Speaker and President Pro Tem, but it requires a 9-person quorum. So the only thing he's challenging there is the quorum. And it's pretty clear that without his folks showing up, if you want to count it that way, the RCC could not take action. So first of all, it can't take action without him. He's got the chair so he can control the agenda and the call and the quorum. And the mere fact that it creates a slant towards the status quo does not mean that the Governor has lost the ability to control or to carry out the laws enacted by the General Assembly. In fact, that may be the General Assembly's policy.
So the supermajority, is it you're contending that the only supermajority provision is a quorum?
Yes, sir.
So the decision is still majority vote?
No, sir. It takes a quorum to act. It takes 9 to act.
So it's
Yes,
not
it's
just quorum?
It's quorum and a majority. Yes, sir.
Thank you.
And the Residential Code Council is under the Department of Insurance.
Correct.
And it was kind of a repeal and replace. Was the previous entity of it also under the Department of Insurance?
Yes, sir. It's breaking out to a greater degree the building code
So
councils.
discuss with us the implication that the General Assembly can assign duties to a constitutionally elected official like the Department of Insurance. How does that constitutional provision square with the faithfully execution provision that the Governor has?
So the argument the Governor makes is that the Governor and only the Governor has the executive power because of the vesting clause, and that because he has power, a duty under the take care clause to take care that the laws be faithfully executed, that he must have final decision making over everything with the executive branch. The Governor and only the Governor is the rhetoric we keep seeing in the briefs. But that doesn't square with history, text, or structure of our Constitution. So history, we've always had a plural executive in North Carolina. Our founders were very fearful of putting all power in the Governor. We had a council that checked even the royal Governor and had some participation even in those decisions. And we carried that through this plural executive into what we formed in 1776. In that way, we were very different than the federal Constitution, which Hamilton made very clear to put all power into one executive. So the fact that there's a vesting clause doesn't in and of itself answer the question, because in the next breath, the Constitution in Article 3, Section 7 creates 9 more members of the executive branch. And then it says they shall have those powers prescribed by law. The Governor would say that they're merely advisory because the Council of State as a body, when you collect all 10 of those, him and the 9, only has the function of advising us to recall the General Assembly. But there's a separate provision that says they shall have those duties prescribed by law. If everything carrying out a law is executive, how can one do that? How can one assign some other duty to the Commissioner of Insurance, the Commissioner of Agriculture, the Secretary of State? There has to be room for the Constitution, or for the General Assembly to be able to do that because the Constitution calls it out. We would say that makes it a political question because it's textually committed to the General Assembly. But even if not, the Supreme Court in the Leandro decision says that a Constitution can't violate itself. It can't be unconstitutional to assign duties to the Commissioner of Agriculture because of the theory that only the Governor has that power when the Constitution says you can't. So that's how we would say. And precedent there is on our side. In Cooper confirmation, Justice Martin, or Chief Justice Martin, who authored McCory, said that the Governor is our state's chief executive. He has the duty under Article 3, Section 5.4 to take care that the laws be faithfully executed. But the governor is not alone in this task. It then says he is joined by a list of the Council of State members who are also members of the executive branch. So it seems to me that the court's always recognized this. I believe that's why it called out those boards and commissions that might be under a separate independent agency under a different Council of State member is something that it was not going to opine on in reporting. Because clearly those folks have to have a role within our Constitution. So that's what we believe is the implication. And for the Residential Code Council, it might be that the governor's appointments alone might not be able to make the day, but it's also a commission or council that doesn't sit under a principal agency that he controls.
So as it relates to the Attorney General,
Yes, sir.
both of our most recent governors served in that capacity prior to becoming governor. They're clearly a part of the executive branch,
Yes, sir.
and they make the decision on which laws to file suit on independently.
I think there would be some dispute as to whether or not that can be controlled by the legislature, because the Constitution says the powers of the Attorney General should have those powers prescribed by law.
And they certainly aren't subject to the governor's authority, right?
But if it's true that the Attorney General has some inherent power that is separate and apart from the governor, it would have to be true of the other Council of State members as well. So again, if that's the argument in other places, and again, that's not really an issue here, but if you conceptualize it, there's no reason to distinguish the Attorney General from the other Council of State members.
Well, as it relates to the Residential Code Council, historically, that's been the purview of the Commission of Insurance,
Correct, sir.
and still is.
It still is.
And he has an appointment to that commission.
He does not have an appointment to that commission. It's only Governor and General Wilson. Although that agency does not enforce. It hears appeals, it makes rules. Enforcement is done either by the state fire marshal or local code enforcement who are certified by a different group.
You have about 3 minutes.
All right. I would
Reserving your rebuttal.
I think we had discussed in implication the Environmental Management Commission, Coastal Resources Commission, Wildlife Commission, in that they deal with the allocation, situations where the governor has most of the appointments, either plurality or an equal number to the General Assembly, and there are 1 or 2 with another Council of State member. That allocation, that fight between the governor, that argument between the governor and some Council of State members with how many appointments are allocated to which, we do not believe implicates the separation of powers. As a textual matter, the separation of powers clause, Article 1, Section 6, talks about the separation of powers. The legislative, executive, and supreme judicial powers of the state shall be forever separate and distinct from each other. So the intramural dispute about how power is allocated within the executive branch doesn't matter. And so as to the EMC and Coastal Resources Commission and Wildlife Commission, we would submit that the executive branch has the majority of appointments and the General Assembly a minority. And so we do not believe that that implicates the same separation of powers concerns as the other cases. We also believe that there is express textual commitment in Articles 3, Section 7.2 to allocate duties between and among the members of the executive branch. I would take difference with the idea that this takes a mockery of our elections. The idea that only the governor was elected to carry out various functions is probably not true when the electorate elects these other members as well. Each of these agencies, the Environmental Management Commission, the Coastal Resources Commission, the Wildlife Commission, touch on other subject matters that are either attached to the Commissioner for Agriculture or the Commissioner for Insurance. And it would make sense if the people are electing them to execute laws in that area, that they would have some say in the allocation. The final point that I would make, and I realize that I'm hitting up against my time, is that the governor has taken an overly broad view of the take care clause. If you were to listen to the governor's explanation of the take care clause, it is that he can see the outcome of ensure the outcome of every vote by every board and commission. That is not what McCoy, and then he makes sure that those reflect his views and priorities. That is not what McCoy and Cooper say. To the extent that there wasn't first of all, the Take Care Clause imposes a duty, not a power, to follow the laws and policies enacted by the General Assembly, which is the policy-making branch of government. But beyond that, to the extent that it has, Cooper recognizes any affirmative power that comes from the Take Care Clause, it is only to make those decisions that the governor is allowed through delegation by the General Assembly. And in footnotes, Justice Ervin clarified that the governor's policy preference means those interstitial decisions delegated to the governor. And I would end on the EMC. Mr. Phillips brought up the point that after the changeover of the EMC dismissed a lawsuit the governor wanted them to bring. The same statutes, though, made clear that the EMC made the decision whether to file that lawsuit independent of the governor. The governor didn't direct them to do it. He didn't have any say over whether they did it. In fact, the Attorney General's office said as much in defending the EMC. So the EMC dismissed a lawsuit. It had full discretion to bring and to dismiss. That was not a decision delegated to the governor, and so it is not one that implicates his take care powers such that it had to reflect his views and priorities. That's the distinction we keep drawing.
I'll give you a moment to sum up in terms of what you'd ask the court to do.
Sir, in terms of what we would ask the court to do, we would ask the court to affirm the panel's decision with respect to the 5 boards and commissions that upheld the EMC, the CRC, the WRC, the Commission for Public Health and Residential Code Council, and overturn the panel with respect to the Board of Transportation and the Economic Investment.
Thank you, Mr. Kelly. Rebuttal?
Yes, Your Honor.
Mr. Phillips, I'm going to give you up to 6 minutes.
You're very kind.
Thank you.
Your Honor, to be clear, we believe that the decisions in McCrory and Cooper and Wallace control here and compel this court to find all 7 of these restructurings unconstitutional. But I also want to point the court to a decision of our Supreme Court issued just 18 days ago in McKinney v. Goins. That decision reinforces the notion that these boards and commissions are unconstitutional, specifically with regard to the 3 boards and commissions where the Council of State members make appointments. In that case, the court discussed at length what it called, and I quote, the fundamental approach by which the court has decided constitutional questions for 2 centuries. That approach requires the court to look at 3 things: the text of the relevant constitutional provision, the historical context in which the people adopted it, and the relevant precedent. The relevant provision is Article 3, Section 5.4, which states, the governor shall take care that the laws are faithfully executed. Not the Commissioner of Agriculture or the Commissioner of Insurance, not the General Assembly or the Medical Society, the governor. And that is buttressed by Article 3, Section 1, which vests the executive power of the state in the governor and no one else. McKinney teaches that whereas here, the meaning of a provision is clear from the words used, we will not search for a meaning elsewhere. And the court expounded on that. The Constitution is interpreted based on its plain language. The people use that plain language to express their intended meaning of the text when they adopted it. Because all political power in this state derives from the people, the Constitution contains no hidden meanings or opaque understandings, the kind that can only be found by the most astute jurist or academic. I would submit to the court that the text of Article 3, Section 5.4 could not be more plain or clear. Similarly, the historical context in which the Faithful Execution Clause was adopted shows that it is only the governor who has that authority. talking about the 1776 Constitution doesn't really matter here, because the faithful execution provision didn't show up in the Constitution until 1868. That was the first time. It was included along with other measures that strengthened the governor, and it has never been changed since. That's of particular historical note, because just 8 years later, in 1876, there were a number of amendments to the Constitution, several of which the legislative defendants point to in their briefs. But there was no change to the faithful execution provision. That duty was assigned to the governor and only the governor. And the people clearly were satisfied with what they had done and did it again in 1971. Finally, examining the relevant precedent, that's McCrory, Cooper, Wallace. And those all say that the governor must have enough control of executive branch boards and commissions to ensure faithful execution of the laws. McKinney is also instructive in its discussion of the power of the General Assembly and the limits on that power. McKinney says, because the people speak through the express language of their Constitution, and only the people can amend it, the General Assembly cannot exceed the express limits placed on it by the constitutional text. When a legislative act goes beyond these limits, the judiciary must use its constitutional power of just judicial review to strike it down. And then it says, no act of the General Assembly could by any means alter or repeal the Constitution.
I have one question going back to what Judge Carpenter asked. The power to repeal that the legislature has, all these are statutorily created agencies. None of these are constitutional. Do you agree with that?
I do, Your Honor.
So if the legislature has the power to create or repeal, that power also includes the power to amend or modify. Do you agree with that as a general principle?
It does to functions, powers, and duties. And functions and powers and duties, the Cooper Court was clear, means what a board or commission is supposed to do, not who appoints it.
And another question I have as it related to Ms. Tilley's argument was the concept that the executive function or executive branch in our Constitution is among the Council of State and not in one person only. I did want you to comment on that as well.
That is certainly true, Your Honor, but it is clear that the people gave the duty of faithful execution to the governor and the governor alone. It says that the governor shall have that power. And that, Your Honor, is a limit on the power of the General Assembly to assign those duties to anybody else. It may not assign them to members of the Council of State. Again, quoting the Supreme Court just a couple of weeks ago, no act of the General Assembly can alter the Constitution. And Judge Tyson, your dissenting opinion in State Board of Education v. State, a case where the State Board of Education challenged Rules Review Commission review of its rules. In that opinion, you included a similar statement that the General Assembly can't alter the Constitution. You included a similar statement of the law that is dead right and on all fours here today. You said, such powers as are specially conferred by the Constitution upon the governor or upon any other specified officer, the legislature cannot require or authorize to be performed by any other officer or authority. And that applies here
Was there a citation of that too?
Yes, sir, Your Honor. You were quoting from Thomas M. Cooley, Cooley's Constitutional Limitations. But you were dead right, and you were on all fours with the issue before this court today. The Constitution having given the governor the duty of faithful execution, the General Assembly is without power to assign it elsewhere. And in fact, the Supreme Court's decision in State v. Camacho echoes that, where the court said that district attorneys had specifically assigned constitutional duties, and a superior court judge couldn't order them to do something that was their decision.
You have about a minute.
Your Honor, going back to what happened after things changed at the Environmental Management Commission and the two Agriculture Commissioner appointees took over and then began to control the policy made by that board. That specifically echoes the concern that Chief Justice Martin articulated in McCrory. When the General Assembly appoints executive officers that the governor has little power to remove, it can appoint them essentially without the governor's influence. That leaves the governor with little control over the views and priorities of the officers the General Assembly appoints. When those officers form a majority on a commission that has the final say on how to execute the law, the General Assembly, not the governor, can exert most of the control over the executive policy that is implemented. As a result, the governor cannot take care that the laws are faithfully executed. He foreshadowed what has happened here. We ask, Your Honors, that you affirm the decisions with regard to the Board of Transportation and the EIC, and that you reverse the other 5. Thank you for your kindness today.
Thank you, sir. Rebuttal?
I would like to address very briefly the idea of control for just a second. McCrory and Cooper 1 are very clear that appointment is not exercising executive power. As they cite in doing so cases that say that appointing an official is merely a mode of filling the office. It's not that. It's not the execution of power too. So simply having a majority of appointments does not mean the General Assembly exercises the executive power, nor that it is controlling the application of that power. Second, as as to state board versus state, there's a difference between the allocation of powers of the State Board of Education, where the Constitution affirmatively says the State Board of Education shall supervise and administer the system of public schools, distribute money appropriated for that purpose, and make all needful rules. Those are powers. They're directives. The plain language of the Take Care Clause doesn't place, and I would take a difference with Mr. Phillips on this, a limit on the General Assembly by its text, but instead on the governor. Take care that the laws passed by the General Assembly, in parentheses, are faithfully executed. Finally, as to the difference between the 1776 and 1868 constitutions, I would acknowledge that the vesting clause was added in 1868. At the same time, provisions that had the Council of State separately elected and said that they would have those powers set by the General Assembly were added. We read all provisions of the Constitution in para materia, just as we do with any other statute, and the Constitution cannot violate itself. If those were both added at the same time, they were both meant to have meaning. Your Honor, I know I'm up against my time, so if there are any further questions.
You have about 2 minutes.
Okay. The other thing that I would point out, and we've made, or 2 things that I would point out. One, there's been a dispute as to where the General Assembly's authority to put these limitations and to structure these boards and commissions comes from. The General Assembly has all power not prescribed by the Constitution. The Constitution is not a grant of power like the federal Constitution, no limitation. And while Section 510 evidences that the General Assembly has control over the organization organization of state government. That is not where this comes from. McCrory and Cooper recognize that there is inherent authority in the General Assembly, and it has been this way ever since 1876 when the Appropriations Clause, or Appointments Clause, was amended to take exclusive power of statutory appointments away from the governor. That the General Assembly has that power. Finally, Cooper recognizes that the General Assembly has lots of powers with respect to structuring these appointments, to specify the numbers of members, the qualifications of membership, such as with the Commission for Public Health, to name certain persons ex officio members, to mandate that differing policy preferences be reflected in the membership, Residential Code Council, the Commission for Public Health, and to determine the substance of laws the Commission is called on to execute. It makes clear that there can be an independent agency and that it is permissible for the General Assembly to insulate a commission from short-term political influence of the government. Those are the types of checks implemented by the structure of these boards and commissions. They do not keep the governor from carrying out any law that he has been charged with by the General Assembly with responsibility for carrying out, or any decision that has been delegated to him.
Why does the General Assembly let the governor have any selections? Your position is that the General Assembly can appoint who they want to, set criteria for numbers of members, who qualifies. Why would the General Assembly allow the governor any of these appointments? Why wouldn't they just appoint them all themselves?
The General Assembly may not, I can't speak for all the members of the General Assembly in their thinking. The General Assembly may think that it is advisable to split up the various constituencies that are represented within the executive branch, but I would also submit that these structures are set in a way to work through the limitations and the exceptions spelled out in McCrory and Cooper to the Constitution. And so there may be some tailoring to the existing precedent that's happening here.
Mr. Phillips thinks this is a test, that there's a smorgasbord to figure out what makes it through and what doesn't.
I can't speak to every member. Thanks, sir.
The case is submitted, and we thank you for your good arguments. If you would remain in place for a moment after we adjourn. This is the reason we visit law schools, is to give the students an opportunity to ask the court and also counsel. So if I may ask that you remain just a moment after we adjourn in order that we can further our learning experience here at Campbell.
Your Honor, I'll note that the last time I was at a law school, I was at Duke, so I much prefer being at Campbell.
Thank you. Mr. Bailiff, will you adjourn court?
This session of North Carolina Court of Appeals is adjourned.
Thank you. We are now in recess, or we're adjourned. I'd like to thank the students who came out today. I think we would all agree that you have had the opportunity to witness exceptional oral arguments presented on both sides by very able counsel. And your presence here today should have enriched you and your practice in being able to see what you're getting ready to do, what you're training to do. And I would compliment both counsel on their, what I consider to be exceptional arguments, and thank you for them. We introduced some of our guests at our last session. Our participants have changed in a lot of ways. The three judges before you here are all graduates of this law school, as was the prior panel. We're very proud of that, and we're very proud to be so close that we can come over and have this and give this opportunity for the students who are here. As far as my own chambers, I have my clerk, Caroline Pope, here, and my executive assistant, Christine Nunn, who is here today. Christine worked at the law school here before coming to my chambers. I also have the rare opportunity today to have my wife, Kirby, in the audience, as well as her staff, Elizabeth and Emily, and also a dear friend of mine who's visiting from Israel, the country of Israel, Israel Stefanski, who's here with us today, and I thank you all for being here today. And Judge Carpenter, you have folks here too, I think.
I do. I've got my clerk is some interns and a resident. Marissa Dunsmore is a Campbell Law grad. And Adam Chalmers is sort of the air traffic controller in Chambers. And then I've got Taylor. I didn't ask you all to refer to what does Taylor say about that. I kidded with her that I may ask a question of the lawyers as to what Taylor says about that. That would have been the Taylor. She appeared to have been pretty good. And then Alexis is a 3L here at Campbell Law.
I also failed to mention that Elon has a residency program where they send law students in our chambers for an entire semester. And I have Dimitri Whitaker, who's here with me from Elon Law too. Judge Murray?
Yes, I have my administrative law clerk, Paul Berger, is here. I've got my two law clerks, Clara Coe and Carrie Ruff, who's a Campbell Law grad.
So we would like to open the floor for any comments. We certainly cannot discuss the outcome of the case because we don't know what it is ourselves yet. So, but we would welcome any comments or any questions to counsel, to the court. And we'd like to have that opportunity at this time for anyone that would like to ask a question.
I can tell you, when I was in law school, there was a 3-judge panel of the North Carolina Court of Appeals that did come to Booties Creek, and I got to see Judge Tyson. So this is a full circle moment for me. And that case was about sweet potatoes.
I booked Judge Tyson's real property planning class. And my crowd over here, if any law students have any questions about internships, what that looks like, clerking, they are ready, willing, and able to answer any questions that you may have in private if you don't want to voice them here to the crowd.
And we do have a reception, which is where business gets done in Raleigh.
Yes, downstairs. And again, if you have interest, if students here have interest in an internship or maybe through a clerkship, we certainly would encourage your interest and we encourage your applications too. And we just thank you today. If there's no further business to come before the court, we will stand adjourned.
All rise. Court is dismissed. just 30-minute limitations.
Right. Right.